Okay, let's dive straight into today's explainer. We are looking at a truly fascinating legal drama from South Africa's Constitutional Court. This is a case that tested the very limits of judicial power, the speed of political maneuvering, and the rigid anchor of constitutional law. We'll be looking directly at the source material from a 2002 judgment led by Chief Justice Chaskalson, which dealt with a massive constitutional crisis triggered by something called floor crossing. To make sense of this complex legal web, we're going to break the source material down into 5 quick chapters. The floor crossing controversy, a period of legal limbo, the KZN5 dilemma, the push for extension, and finally, the principle of finality.
All right, Chapter 1, the floor crossing controversy. Let's get right into it.
So the whole thing kicked off in June 2002, when the South African Parliament made a highly consequential move. To understand the massive stakes here, we really need to grasp this concept called floor crossing. Think of it literally like a star player just up and changing teams right in the middle of a sports season. Parliament tried to make this perfectly legal, basically allowing politicians to abandon the party that originally elected them, join a rival party, and, here's the kicker, actually keep their elected seats. To pull this off, Parliament rapidly pushed through 4 separate acts in June 2002. You've got the First Amendment Act and the Local Government Amendment Act handling the local municipalities, and then the Second Amendment Act and the Membership Act handling the much higher stakes of the national and provincial levels. But as you can imagine, changing the rules of the political game this drastically, it didn't go unchallenged. The United Democratic Movement, or UDM, immediately sued in the Cape High Court, arguing the whole thing was completely unconstitutional.
Which brings us to Chapter 2, a period of legal limbo. Now, once the courts stepped in, the legal ground shifted incredibly fast. Just look at this timeline. In June, right after Parliament passed the acts, the Cape High Court essentially hit the brakes and suspended them. By July 4th, it had escalated all the way to the highest court in the land, and the Constitutional Court issued a temporary freeze order just to stop the bleeding while they heard the full arguments. And then finally, on October 4th, 2002, they dropped their main verdict.
And man, that October 4th ruling was a total bombshell. The court said, okay, local floor crossing, that's legally sound. But national and provincial floor crossing, specifically governed by the Membership Act, was struck down as completely invalid. Why? Because you can't just pass a regular, ordinary law to change the fundamental rules of democracy for national and provincial legislatures. You need a full-blown constitutional amendment.
So that takes us to Chapter 3, the KZN5 dilemma.
So, what does this high-level, abstract constitutional theory actually mean for real people whose jobs are suddenly on the line? Well, let's look at 5 specific politicians in the KwaZulu-Natal provincial legislature. We'll call them the KZN5. Here's their massive dilemma. On June 21st, these 5 individuals had actually crossed the floor. They left their original parties to join the African National Congress. Crucially, they claimed they had zero idea that a judge in the Cape High Court had suspended the legislation the very day before. So when the Membership Act was officially declared invalid in October, these 5 politicians were literally sitting in seats they legally had no right to occupy.
Knowing this was going to cause absolute chaos, the Constitutional Court threw them a bit of a lifeline. On October 4th, they created what they called a breathing space, basically a temporary order protecting the seats of anyone who had already crossed the floor. But, and this is a massive but, it came with a strict expiration date, October 22nd, 2002. The court essentially started a ticking clock. Everyone had exactly 19 days to figure out a fix before the legal protection vanished entirely.
So, the clock is ticking, right? In response, on October 11th, the Minister for Justice tosses out a legislative lifeline. He publishes a brand new Constitution Fourth Amendment bill. This was exactly what the court asked for, a proper, formal constitutional amendment designed to apply retroactively to cover those who crossed the floor back in June. Sounds like the perfect fix, right? Well, actually, scratch that, there's one glaring issue. Lawmaking is notoriously slow. There was literally zero chance this new bill was going to pass through Parliament before that October 22nd deadline hit.
And that frantic scramble leads us into Chapter 4, the push for extension.
So it's October 22nd, the absolute last day. The interim protection is expiring in a matter of hours, and it is a desperate legal scramble. Both the ANC and the minister rushed straight back to the Constitutional Court for an urgent direct access hearing. It was a true down-to-the-wire moment. If that clock struck midnight without a court extension, the KZN5 were going to lose their seats instantly.
Now, both of them wanted an extension, but they were asking for very different things. The ANC's application was pretty straightforward. They explicitly asked the court to push the deadline back until the new constitutional amendment bill was either passed or rejected by Parliament. They just wanted to keep their new members in office. The minister, though, filed a counter-application with a slightly wider lens. He asked to extend the protection all the way to March 31, 2003, mainly because he was terrified of the broader legal uncertainty. What happens to all the decisions made by the legislature while these unauthorized members were sitting in it?
Which brings us to our final act, Chapter 5, the principle of finality.
So both sides are essentially begging the Constitutional Court to bend its own rules and change the deadline it had already set. But can a court actually do that? To answer that, we have to talk about a really foundational legal doctrine called functus officio. It literally means having performed his or her office. Basically, once a judge bangs the gavel on a final decision, their job is done. Their authority over that specific matter completely ceases. They generally cannot go back and rewrite it, alter it, or supplement it just because the political reality on the ground got messy.
Chief Justice Chaskelson, leading a unanimous court, leaned heavily on a powerful precedent from an older case, the Firestone case. He quoted Judge of Appeal Trollope, cementing the idea that the finality of a judgment is absolute. I mean, sure, there are very rare exceptions, like fixing a typo or clarifying a genuine ambiguity. But the ANC wasn't asking to fix a typo. They were asking for entirely new, substantive legal relief. And Chaskelson made it crystal clear the court's hands were completely tied.
The court stayed strictly neutral in its findings here. They pointed out that the ANC's entire argument rested on a massive assumption, the assumption that Parliament would eventually pass this new constitutional amendment. But courts deal in cold, hard, present facts, not future political probabilities. As Chief Justice Chaskelson noted, a court absolutely cannot grant relief based merely on a guess about what politicians might do down the road. It's absolutely crucial to remember this. To do otherwise would essentially be giving legal force to a law that the court had just declared invalid on October 4th. There was no way they were going to do that.
So when the dust finally settled, the legal rug was completely pulled out from under the politicians. The Constitutional Court dismissed both the ANC's application and the minister's counter-application and even ordered them to pay the legal costs. Because no extension was granted, the interim protection expired exactly when the court originally said it would. The KZN5 lost their seats immediately on October 22nd, and literally the very next day, on October 23rd, the Speaker of the KZN legislature swore in new members to replace them. The law, with all its rigid, uncompromising finality, took its course.
And that leaves us with a really fascinating, provocative thought about the very nature of our legal systems. We're seeing this intense, head-on collision between the rapid, often incredibly messy speed of political strategy and the unmoving, absolute anchor of constitutional law. When politicians move faster than the legal frameworks holding them up, the fallout is swift and it is severe. So it really makes you wonder, how should a healthy democracy balance that inevitable desire for political flexibility with the absolute rigid finality of the law? It's a massive tension, and it's one that continues to define constitutional democracies all over the world today. Thanks for joining me for this explainer, and I hope diving into this source material has given you a whole new perspective on just how delicate that balance really is.